It immediately takes your lordship to the provisions of Article 63(1)(g) and H, and there the limits are specified. Their lordships then make a further distinction, and that's again SAMAA Baloch, that a person who has been convicted has then paid his debt to society, forever suffers the odium of being a convicted criminal, and therefore he is in a different league than from a person who suffers a civil liability. Parliament doesn't make that distinction. The court does. It is the interpretation of the court which is making the constitution redundant. My lord, that logic also does not hold. Why it does not hold? My lord, in criminal law, and my knowledge of criminal law is very, very peripheral, and your lordship will excuse me for that, but I make a distinction always between conviction and sentence. A person serves out a sentence. A person never serves out a conviction. The conviction remains on his record forever and ever. If he has served even till the rising of the court.
Maghdub Ali Khan, that's another matter which is pending adjudication in this court. I am of the view, and others of a different view, and I had requested for a larger bench to be constituted, and I may be failing in my duties not to have done so myself, but so much has been happening, we're working morning to night, was that in a murder case, 345 allows compounding of an offense. There are two views in this court prevailing. One view is it brings the sentence part to an end. It does not efface the conviction. The other view is it effaces the conviction and the sentence both. So even if we apply that debt to society part, suppose a person commits murder and next day secures a settlement with the legal heirs, where is the debt to society has been paid? It hasn't been paid. He will file a nomination papers. Have you been convicted of an offense? Answer will be no. If that interpretation of the Constitution is followed, which says that it effaces the conviction and the sentence, he will honestly answer no. Whereas if the interpretation which I have favor holds, he will say yes. Sentence part would be a different part. So even though he didn't pay debt to society, did not serve one day in jail, he still can contest election in that scenario. So this debt to society argument, I also find a bit fallacious.
But look, that's this. I guess let's wait for a larger bench on that question, because that will take us yet to another argument altogether.
I think I should not be a member of that.
For the debt to society argument,
it's already there, my opinion, written.
Debt to society argument in the SAMAA Baloch case, when your lordship looks at 63(1).
So, Mr. Maghdub, I mean, taking up that argument that you said, court of law could be both. So when it's criminal, then of course 63 gets attracted, but when it is civil, 63 doesn't get retracted, it stays where it is, and we have to deal with it.
Yes.
So there is a declaration which is civil, arising out of original jurisdiction, the way we're looking at it, and is calling somebody a fraudster. Now the question is, how do we put a time frame on it? There's a decree standing in your face saying that you're a fraudster. Now what do we do with it? How do we treat that decree and think of it that it has a time bound or it doesn't? Because inter-party it probably stays forever.
Lord,
but for elections, should we take it differently?
Let's come to the time bound question. Time bound question immediately.
I will add to my lord, whether that time will be started from the date when decree was passed or from the day when the elections are called.
Because also that there's no dispute to the fact that inter-parties that stays forever.
Inter-parties
that stays forever.
Inter-parties
unless it's set aside, of course.
That's true.
But for elections, perhaps a different treatment needs to be given.
And my lord,
how do we do that?
For the reason is, Parliament over here, even in the 18th Amendment, doesn't say that the declaration will remain forever.
Right.
They are silent, and they're silent from D and E and G don't talk about a declaration at all, but again don't mention a period of time.
Right.
F mentions, don't mention a period of time or mention a court. F mentions a court. Now, is this declaration going to be, as was pointed out by one of the amicus, till the time of the next election, for the present term, or forever? Generally, when your lordships have looked at questions where no time has been specified, your lordships have consistently taken the view that it has to be a reasonable time. My lord, to give an example which obviously comes to mind from civil law jurisdiction, there is no time specified for filing a revision under section 115 of the CPC, if I correctly remember.
Before we has been inserted 90 days.
90 days.
Now it is 90 days, but they didn't used to be, even when there wasn't.
Before we come to that reasonable time argument, first of all, you need to understand the basis. If the decree stands for life till such time that it's set aside between parties, why should it be given a different treatment for election purposes? What's the philosophical answer to that? Because if inter-party it stays forever till such time it's set aside, how would it be different, or why should we even consider it to have a time frame for the purposes of elections?
My lord, for two reasons. Number one, if that decree comes in the context of elections, it is simply impossible. An election tribunal makes one of the four declarations. It either dismisses the petition, or declares the election as void, or declares the election as void and directs that the particular candidate may be declared as a returned candidate, or declares that the election to be void as a whole.
Re-election.
That used to be the situation under ROPA. That is the situation even now under the Election Act. For offences under the Election Act, for corrupt practices, for illegal practices, the session judge tries them. Now some of them tried by Election Commission, some of them by the session judge, and we need not go into that question. PPC itself has a chapter on election offences and where punishments are prescribed. Your lordship will notice that when your lordship looks at corrupt and illegal practices, the maximum punishment of illegal practices in none of those cases exceeds 2 years. So only for the corrupt practice that it can go for a longer period. The principle of proving a corrupt practice is beyond a reasonable doubt, and therefore my respectful submission is that the parliament was thinking of those kind of declarations when it talked about a declaration under 62(1)(f). This business of a civil law declaration, with great respect, has been introduced by this honorable court, introduces that a civil liability will virtually strip a citizen of his fundamental rights forever and ever. That was not something which the parliament has done, because if your lordship reads F with G and H, they make perfect sense.
अब देखिए मखदूम साहब एक बात और जरा, suppose अगर कोई court, civil court say declare somebody that he is cheater, he has cheated somebody, makes fraud, committed a fraud, और उसका राइवल जाके उसके खिलाफ FIR दर्ज करता है अंडर PPC section 415 and 420, और FIR के बाद he is convicted, conviction के बाद तो वो उसको सजा मिल गई, क्या फिर भी वो सारी जिंदगी ऐसा ही रहेगा कि वो he is debarred from contesting elections?
Sir, in that situation you will have an absurd situation. The absurd situation would be that on account of that civil liability he will be forever disqualified, but insofar as the criminal liability is concerned,
talking about civil declaration, किसी के खिलाफ डिक्लेयर कर दिए
जी सर,
वो तो टाइम नहीं देगा जी, सिविल कोर्ट तो ये नहीं कि you are debarred from, वो सिंपली कहेगा you have committed fraud
जी जी
by changing the documents और जो भी दूसरी पार्टी कहती है कि चूंकि आपके खिलाफ एक डिक्लेरेशन आ गई कि आपने चीटिंग की, वो जाके FIR दर्ज कर देती है, FIR की बुनियाद पर PPC में जाके क्रिमिनल कोर्ट में चल रहे तो वहां पे सजा हो जाती है 2 साल 5 साल जितने भी, क्या सजा खत्म करने के बाद स्टिल उसके सारी जिंदगी डिस्क्वालिफिकेशन
5 साल?
सर 63(1)(h) के तहत उसकी डिस्क्वालिफिकेशन खत्म हो जाएगी, लेकिन अगर
वाली बात है कि उसको 63 के साथ पढ़ा जाए,
अगर समीउल्लाह बलोच सही फैसला हुआ है, if समीउल्लाह बलोच has been correctly decided, then on account of that civil declaration against him, he will be disqualified for life. So in spite of the fact that under a criminal declaration he has paid his so-called debt to society, under the declaration made by civil law,
debt to society argument कहीं constitution में है?
नहीं है.
नहीं तो देखिए वही बातें हैं, we're getting bogged down into things.